Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Dylan Gilbert, Policy Counsel at Public Knowledge. We will discuss the new white paper, Making Sense of the Termination Right, How the System Fails Artists and How to Fix It, which he co-authored with Meredith Rose and Elisa Valentine. So welcome to the show, Dylan.
Thanks for having me, Brian. It's great to be on.
I'm really excited to have you because the termination right is something I've been interested in for a long time. I feel like I don't really understand it all that well, and I think I'm not that alone in not understanding it all that well.
I think if someone says they understand it thoroughly, then they're trying to sell you something.
So Dylan, for listeners who are in the same boat, maybe we could start by just having you talk a little bit about what the termination right is and why it was created.
Sure, yeah. So the termination right is a small but very powerful right in sections 203 and 304 of the Copyright Act. I kind of call it like the Mighty Mouse of copyright rights. It's an inalienable right. You can't sign it away through contract. Immensely powerful. But it's kind of operates in some ways in the shadows, partially because, because of its sort of, I guess, complexity, and also because I think, as we'll probably touch on a little bit later on, there's a lot of incentive to sort of keep it sort of in the background and out of sort of public awareness, but. Generally, what it does is it allows for an artist who has assigned away or granted the rights to his or her creative work to usually like a business of some sort that the artist will partner with to promote, distribute. Earlier on in their career through a contract. After a certain time has passed, a minimum of 35 years, the artist has the ability to exercise their termination right and reclaim, essentially terminate that grant or that license from earlier on and reclaim the right, again, regardless of what the contract said. Also, importantly, in an alternative sort of approach is the artist could say, hey, I want to take my rights back through the termination right. How about instead of me doing that, we renegotiate our contract or negotiate a new contract with more favorable terms for me, or just something that could be updated that could be more mutually beneficial. And so this was something that came about in the 1976 sort of Copyright Act. Congress was looking to sort of revisit the way that rights sort of worked, and kind of came at this from a sort of two-pronged policy approach. One of which was an economic sort of rationale, and one was a more sort of moral or equitable rationale. Basically, the idea from an economic standpoint was, as I mentioned before, potentially an artist could become a lot more successful later on in their career, and Congress wanted to be able to give that artist the opportunity to sort of share in that success. And then sort of from a moral standpoint, there were a lot of artists that were subject, particularly back then. I think it's gotten a lot better now, but regardless, even today, when you're starting out in your career, you're essentially an unknown, have a lot of potential. Otherwise, you wouldn't be qualified, or there wouldn't be sort of grantees interested in working with you. But there's still sort of a lack of bargaining power on the part of the artist at that stage in their career. And so what this allows is to sort of get the artist a chance to come back and revisit a contract that they might have signed with a better potential bargaining power later on, now that they've gained some fame, some notoriety, and some success.
Well, so as I understand it, then the idea behind the termination right is essentially that if an artist or author sells the copyright work to a publisher at an early point in time, at a later point in time, the termination right statutorily gives them the absolute right to reclaim copyright ownership of that work of authorship, irrespective of what the original contract had to say. In other words, it's sort of like a reversion, as it were, of the works to the author after a certain period of time.
Exactly. That's right. And so it's, in fact, sometimes you'll hear folks talk about the termination right as a reversion right. But kind of, I guess, importantly though, it's not an automatic reversion. You have to go through sort of a series of steps. There's sort of timing, eligibility, and kind of formalities requirements that are attendant to exercising the right, which can get quite complicated. As those that are listening that are law students or law professors know, at least for me personally, the termination rights section on my copyright final exam was the bane of my existence, because oftentimes you're given a fact pattern with sort of, complex dates, lots of numbers floating around, which most lawyers are not particularly fond of, which is part of the reason why they became lawyers and not engineers.
Well, so I understand that there are a lot of difficulties attendant with actually asserting the termination right. And you talk about the kind of complications associated with the requirements for doing it. But then there's also certain kinds of limitations or kind of unclear circumstances that affect the ability of an author to exercise the termination right. But I wonder, for listeners for whom this actually might be valuable, you might talk a little bit about what authors actually have to do in order to exercise the termination right, and where the problems might crop up.
Yeah. So basically, when the sort of grant took place is usually going to be sort of the guiding light in terms of which statutory provision applies. And so, for example, 17 USC Section 203 governs grants that were made by an author on or after January 1st, 1978. Regardless of when the copyright was first secured. So obviously for a lot of folks that are probably like our age, for example, the Section 203 provision would be the one that would govern and would be doing so going forward. But for a lot of legacy artists who either sort of secured their copyright or granted over their rights before 1978, sections 304 or section 304C and 304D would apply. And I think that probably the easiest way to sort of maybe illustrate kind of how this could be complicated would just be to take like a particular example. So imagine that you're an author, you get a copyright in a biography that you wrote on June 1st, 1960. So, obviously this is 50, almost 60 years ago now. It is 60 years. Wow, it's 2020. So, this is quite some time has passed. The author or the author's heirs granted the rights in the book in perpetuity to a publisher at that time. So Section 304C would apply. And so the first thing that you have to look at if you're the artist, or more likely you would sort of need to hire a lawyer it would be wise to try to hire representation to navigate this, is you would need to find when the date of termination, like when you even qualify to terminate, would take place. And so under the statute, that date of termination would need to fall between June 1st, 2016 and June 1st, 2021. So there's this 5-year window. And the author gets to choose what that date is. So if the author chooses June 1st, 2020, coming up here in 6 months as the date, what the author needs to do is file a notice of termination to record it with the Copyright Office. And the notice would also need to be served on the publisher. But there's sort of another separate window of time that governs when you can serve that notice. It would have to happen on or after June 1st, 2010. It couldn't come any earlier than that, but it would have to come before June 1st, 2018. So it's kind of like, in other words, it can't be earlier than 10 years before the date of termination, but it can't be later than 2 years prior. So that would just be an example of like the timing, but there's going to be eligibility requirements, and then there's formalities requirements with regard to like what the notice and sort of recordation involves. So those types of things can prove to be quite vexing in and of themselves for artists and lawyers and law students. But then, just to answer sort of the first part of what you mentioned earlier as well, you also have exceptions to the termination right, and something that we cover relatively extensively in the paper. One of them is the work for hire exception, and the other one is the derivative works exception. And just to do very quickly on the work for hire, works made for hire, which is its own doctrine and copyright law, those do not qualify. The termination right will not apply to those, which kind of makes sense, right? Like if you're a graphic designer and you create a design as part of your employment for an agency that you work for, it wouldn't really make sense that you would be getting the rights back to that, because frankly, under the way the doctrine sort of the way the law operates, you never owned the rights in the first place because you did it within the scope of your employment for your employee. So they own the rights outright from the beginning. So it's a little bit, in some ways, kind of a misnomer to call the work for hire an exception, because there never really was an ownership involved that was granted over in the first place. But this can be, as you can probably imagine, very complicated if the contract that you signed said that what you did was a work for hire. Because frankly, as you know, as a law professor, the works made for hire, it's whether it, outside of a few specific statutory, things that are outlined in the statute, mostly this is a judicial determination. And so if your grantee says, if you say, I want to terminate my grant, and the grantee says, sorry, tough luck, it was a work made for hire, chances are that might be something that's going to go to litigation. So, as you can see, like we're starting to pile on some layers here of complexity, and it can create for some headaches and frankly, for some real undesirable outcomes for artists. If you have what's supposed to be an inalienable right, there shouldn't be an incentive or a structure in place, in our view, that would sort of lead to a likelihood of litigation or even confusion as you're trying to exercise this extremely powerful right.
Well, I got to say, I mean, it seems kind of weird because the 76 Act is sort of notorious for, among other things, largely eliminating the formalities associated with copyright ownership. And yet this one subset of the Copyright Act seems to reintroduce formalities in a really kind of awkward and inefficient way.
Yeah, it's right, exactly. It's kind of like you saw formalities kind of have usually sort of been associated with Berne conventions and the influence of that on U.S. copyright policy. But like you mentioned, yeah, it as far as I can tell, and maybe you were able to dig up some information on this, but I'm not entirely sure why this was in place, why these formalities were, I mean, obviously, there needs to be some mechanisms here for the Copyright Office to keep its house in order, so that it's just not completely, unmanageable from an administrative standpoint. But if we're talking about creating this enormously powerful, artist-friendly right, it seems counterintuitive to start making it very difficult to exercise. So this could have been, who knows? This could have been a product of lobbying on the part of certain industries or the Copyright Office itself. Who knows? Do you happen to know what the answer is there?
Yeah, I mean, it's my understanding that the termination right was sort of a rethinking of the way that renewal worked under the 1909 Act and previous versions of the Copyright Act, because the renewal right was also non-alienable in the way, or at least partially non-alienable in the way that the termination right was. And so the termination right, as I understand it, and this is mostly from Zvi Rosen's explanation, was intended to sort of formalize and expand that right. But as you say, I mean, it does seem like it's been really difficult for a lot of artists, even artists who are very famous and successful, to actually exercise. So, I mean, I wonder if you could talk about some examples of circumstances where people have maybe tried to exercise the termination right and ways in which it was either really difficult or maybe arguably didn't work.
Yeah. So, I mean, my whole journey on this kind of got started. It was, my interest was piqued from an article that I came across, which I believe was in Billboard. We cited it in the paper that was just sort of kind of inside the artist's struggle with their termination right type piece. And it was talking about how there were reportedly a number of artists who were pretty significantly well-known artists that were struggling to reclaim their rights. The one that jumped to mind is Billy Joel, who, I mean, we're talking about, an enormously wealthy, successful artist, again, who apparently was unable to get his rights back. But a lot of this appears to be in dispute, where there would be some lawyers that work on this every day, that at least in that article, for example, said, yeah, we're having some success with our artists getting their rights back, but then some executives of publishers or other grantees like record labels would be like, no, that's not the case. The problem here with regard to some of that stuff is that a lot of these negotiations and settlements are under non-disclosure agreements. So we've got a real kind of lack of public information. A lot of this is coming through reporting and other anecdotal evidence, which kind of exacerbates some of these information asymmetries that we were talking about earlier, and can make for tricky policy making when it's like, well, as mentioned earlier, a lot of these grantees are sort of incentivized to keep the results of the negotiations sort of under wraps, because to the extent that an artist might be successful in getting back their rights, that would sort of signal to other artists, hey, like, oh, my friend over here got his rights back, I should go do that. And when you have companies' valuation in many ways is tied up with the sort of catalog of rights that they might have, a lot of companies are incentivized to hold on to these rights for as long as possible. So it's a challenging environment with regard to trying to get some information about this stuff. We also saw some evidence in litigation of artists that were having some difficulties in getting their rights back. One case that we talk about is a case involving Victor Willis, who was a founding member of the Village People. And what was happening in that case was something that we haven't touched on yet, but was the interplay of the statute of limitations with the termination right. And in that case, there was sort of an ownership dispute. And you would see this a lot in any kind of work where there might be joint authorship. Various authors that might, particularly if the work becomes more successful later on, various authors that might be able to say, hey, no, I'm an author as well. If under the way that sort of the case law is developed, if there's a repudiation, an express repudiation of an ownership claim, that can start the 3-year statute of limitations running. Well, what happened in the Willis case was the publisher challenged his notice of termination, basically said, no, Willis, you don't own the rights in question because you had transferred them to a publishing administrator. So, the ownership dispute that was important to the termination right, because if he didn't own it in the first place, he didn't have any rights that he could terminate. That was potentially something that was barred by the statute of limitations. there was a kind of protracted litigation that was involving the interplay there between the statute of limitations and the termination right. Now that one actually came up with a happy ending for Willis, as far as we could tell. But another kind of interesting side note to that litigation was he didn't even know about the termination right at all as an artist, and said that the only reason that he was able to sort of know about it in the first place was because his wife was a lawyer. So again, this kind of gets to back to this idea of how the termination right is this very powerful right that doesn't appear to be have much of a high profile, particularly with legacy artists who are the ones that would be most ripe to exercise this right, because now the sort of decades long period has elapsed.
In my experience, the termination right is generally conceptualized as sort of something that gives artists who've achieved success in their careers a sort of second bite at the apple for works that they created and transferred early in their careers. And, to the extent that people kind of have a preference for seeing the proceeds from works of authorship go to the authors rather than to the publishers, I guess that makes sense. But the aspect of the termination right that I found really interesting and compelling was pointed out to me by Rebecca Giblin and others, which was that in a lot of cases, publishers kind of have works in their catalogs that maybe they're not really doing anything with anymore. And part of the purpose of copyright is, at least in theory, to encourage the distribution and availability of works. And it seems like authors might have more of an incentive to do that than publishers in some ways. I mean, do you think that's an important aspect of why we should be interested in and supportive of assertion of the termination right?
Yeah, absolutely. And I think, as you mentioned, we're seeing this as an issue probably more so with sort of book publishing, maybe than, for example, something like music, because a lot of music back catalog we're seeing now available through Spotify, Apple Music, other places like that. But there's a significant sort of crater. I almost just envision it as if I'm looking at it like a graph in terms of the availability of 20th century works in print from sort of like a book publishing standpoint. And as you mentioned, we want to be promoting the accessibility, the availability of creative works, and also allowing artists to take those works that they created and do something new with them if they so choose. And so I think that in that regard, yeah, that's a real important aspect of the termination right conversation, is saying, hey, if we've got a bunch of stuff that's not being utilized, it's not being promoted, it's not being distributed or shared with the world, that's something that we should be trying to fix.
Well, so in the white paper, you suggest a number of potential changes to the termination right, both maybe statutory, but also interpretive changes that might make it more effective and more consistent with our policy goals. I wonder if you could talk a little bit about some of those suggestions and why you think that they would be valuable.
Yeah, absolutely. So we went through kind of a litany of potential fixes and explored maybe some of the pros and cons or the practicality of some versus others. The first one would be sort of the most kind of common sense, but also probably the most radical, which would be just basically to make it so that the termination right vests automatically. So you don't have to go through all of this. It's kind of, as you mentioned, the sort of provisions in the 1909 Act where the rights would revert back automatically. It would be kind of going back to something like that, where you don't have to go through the sort of the filing, the formalities, the timing, et cetera, et cetera. And that could help to sort of address some of these information imbalances. Of course, there would need to be some sort of mechanism for the artist to like opt out of that or to delay it if the artist wanted to renegotiate the terms, because as mentioned earlier, it's not just about necessarily getting your rights back. It's also using the ability to get the rights back as leverage to potentially get a better deal. But I think this would be enormously challenging for a number of reasons. One of the key flaws to this as a standalone fix, in my view, would be that the work for hire and derivative works exceptions would still be in play. And from our investigation, a lot of the litigation that we see, or at least the legal challenges to notices of termination, are related to the work for hire exception. So just simply, having an automatic vesting without addressing some of the exceptions would likely be insufficient. And this is, of course, something where you can imagine that the grantees would not be particularly thrilled with this possibility as well. Another potential would be kind of getting back to addressing this lack of availability of published works, would be to revise the Copyright Act so that the termination right vests sooner than it does now. Some things that could be good here would be it could reduce the number of disputes over heirs, things of that nature. That would be kind of in contrast to the termination right vesting automatically, which would probably be very challenging to see how that played out with regard to joint authorship disputes. Could be a little bit easier here if it vests sooner, because there's more of a likelihood that the author or authors would be alive. Also, maybe an increase in documentary evidence. But again, as you mentioned, there while it could be good in terms of helping to get some of these works that are out of print or published works that aren't being distributed back into distribution or in the public eye, it would be some interesting complications in the world of music, where music catalogs, back catalog is now increasingly valuable and available at our at a click of a button or a tap on our phone, and there could be some decreased leverage for grantee and the sound recording space, for example, to negotiate better terms for their artists if they have a less valuable catalog to negotiate with. So that there's a kind of an interesting interplay with music in that particular area. Another one would be to eliminate or revise the work for hire exception. This would be something the most radical, again, would say, rather than works for hire not qualifying for termination, just saying that it's not something that you can rely on as an exception anymore. Of course, then we have a problem of a number of the aforementioned graphic designers coming back and trying to and terminating their sort of contract that they had with their graphic design firm to get rights to something that they really shouldn't have had in the first place. But again, as mentioned before, like in the sound recording context, although most of the case law seems to indicate that courts are unlikely to find that a sound recording, for example, would be a work made for hire, it's still something that is unsettled, and some of those like incentives to go to litigation could be eliminated here. I think that probably the most common sense fix with regard to works for hire or that general universe would be with regard to loan out corporations. A lot of artists, as far as I can tell, still are using loan out corporations to engage in the contractual negotiations. So if you form a kind of corporation, this can help for tax purposes and accounting purposes. But then if your loan out corporation is assigning the rights on your behalf, there becomes a real question about whether that loan out whether you are the author anymore, or whether it's a loan out corporation, whether, you're doing something as a work for hire. It can get really kind of convoluted. And to sort of eliminate the incentive to have to litigate these types of disputes or the sort of uncertainty surrounding this, it seems very common sense to just sort of figure out some way to make it clear within the law that, a grant that is executed by an author through his loan out corporation would still be deemed to be executed by that author. So that's sort of a work for hire adjacent type of fix that seems common sense. Another one would be sort of trying to address this statute of limitations issue that I mentioned before in the Willis case, where you've got potential ownership disputes tolling the statute of limitations and not allowing an artist to sort of exercise their termination right as they would like to do, because the ownership dispute sort of obviated their ability to exercise their termination right later. So one thing that you could do would be to just create a limited exception to the statute of limitations for purposes of termination rights, in which any joint authorship claims that were brought in the context of a termination right would be exempted from triggering the statute of limitations. Of course, if you've got a very well documented repudiation of an ownership claim on the part of a grantee, where they're like, no, look, we've got this clearly in writing that you're not the author. It seems like that would have to be sort of an exception to the exception. It gets complicated here as well. At a minimum, one thing that we suggest that we think is relatively common sense or could be potentially a path forward would be to sort of codify the holding from a case called Wilson versus Dynatone, which basically said that merely registering an adverse claim in the Copyright Office is not an effective repudiation of ownership. That was something that was done, a case that involves Section 304. So that would sort of need to be extended to Section 203 as well. But that could be maybe more of a targeted fix. But, ultimately, as you can tell, with all this complexity, a lot of sort of political challenges, and as mentioned before, kind of a lack of public information because so much of this stuff is tied up in NDAs. We really think that the best first step would be for the Copyright Office to conduct a formal study of the termination right. And so, we would need Congress to sort of have the office conduct a study with an eye towards investigating all these issues that we've talked about, the stuff that's been brought up in scholarship and in litigation, and look to see what would be really kind of investigate how this is operating in practice now, and hopefully find some good targeted solutions that can help to address some of the dysfunction that we're seeing in this regime. Of course, this would be a little bit challenging still because the Copyright Office, it doesn't have to, it can't really compel, a grantee like a publisher or a record label to just turn over their settlement agreements or things that are under non-disclosure agreements. So there would probably need to be some sort of mechanism put in place where grantees could voluntarily submit some of these documents under seal or in redacted form, some kind of thing like that, which hopefully they would be willing to do. That could really just sort of pull the curtain back a little bit on this, see how this is working, where it's not, and allow for some good policy making to take place.
Well, so Dylan, in closing, as I'm sure you know, a lot of people argue that we should have a shorter copyright term than we do. And I know that some people have suggested that maybe termination should just be termination of copyright entirely rather than termination and reversion to to the author. I mean, I wonder what you think about that. And do you think there are advantages to having a termination right that does include a reversion to the author? Or, how should we think about that, about termination and reversion in the context of kind of policy concerns about the copyright term itself?
Yeah, I mean, I think absolutely that we should consider authors to be the best custodians of the rights in their works. This is the product of your creative output. This is in many ways your livelihood. And while it is fair to say that partnering up with business partners and such to help to promote, distribute your work can be quite valuable. Ultimately, the way that you want to participate in the culture and want to control your work should be in your hands. And so, I think that artist empowerment is sort of the key here, taking creative control of your livelihood, and only the artists themselves really knows best how this art should be shared with the world, and how it should be. What the sort of future should be for this creative work. And so it makes sense to, I think, empower the artist to do what they can with this, and to not expect an artist to have to wait around potentially towards the end of their life or after their life is over to make decisions about something that is the product of their creative output, and as I mentioned before, is their livelihood. So we need to make sure that we're putting artists in control of their futures here.
Thanks, Dylan. I really appreciated this conversation, and I learned a lot about the termination right and how it works.
Thanks for having me on. It was a pleasure.
Look what they done to my song. Look what they done to my song. It was the only thing that I could do half right, and it's turning out all wrong, Ma. Look what they done to my song. Ah, look at what they done to my brain. Oh. Look what they done to my brain. Well, they picked it like a chicken bone, and I think I'm half insane, Ma. Look at what they done to my song. I wish that I could find a good book to live in. I wish I could find a good book. Well, if I could find a real good book, I'd never have to come out and look at what they done to my song. Ils ont changé ma chanson, ils ont changé ma chanson. C'est la seule chose que je peux faire, et ce n'est pas bon. Ils ont changé ma chanson, but maybe it'll all be all right, Ma. I'll buy in tears, I'll be rich someday, Ma. Look what they done to my song. Look at what they done to my song, Ma. Look what they done to my song, Ma. You know that they tied it up in a plastic bag and turned it upside down. Oh, Mama, look at what they done to my song. Da 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 da. La da 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 da. It was the only thing I could do all right, and it's turning out all wrong. Oh, Mama, Lord, what they done to my song.